Hi, this is Paul Taylor from Truckers Justice Center. I want to talk today about mitigation of damages. So we are a law firm that represents truck drivers usually in employment-related disputes, wrongful termination suits because a driver won't break a DOT regulation, or discrimination on the basis of sex, age, things of that nature. So if you have a claim of any type in any lawsuit where you're seeking to get money, it could be a breach of contract claim, which typically we don't mess with those too much unless it's an owner-operator lease dispute. But when you have a claim, a personal injury claim, a breach of contract, an employment claim for wrongful termination, you have a duty to attempt to mitigate damages. So what does mitigation mean? It means in the context of an employment-related suit where you're wrongfully fired either as an owner-operator or as a company driver, you need to look for substantially equivalent work. Think of this as an analogy. Suppose you are injured in an auto crash. You're minding your business, you're driving your Subaru or your Ford Escort or whatever you're operating through a green light at an intersection. You're paying careful attention, and a drunk driver driving 90 blows through a red light and T-bones you and injures you. Great claim on liability. Obviously, the other side is screwed if you bring a lawsuit, at least on liability, but an element of a lawsuit always involves a claim of damages in an injury suit. So you can't sit back and bleed in that auto crash and say, well, I'm not going to go to the doctor, or I'm not going to follow the doctor's advice, or I'm choosing not to go through the physical therapy recommended by my doctor. You're not allowed in a personal injury suit to cover for damages that you haven't attempted to mitigate. You might get something, but you can't sit home and not do anything. Same thing applies in an employment law related suit. If you're fired illegally, you've told your boss, I'm not going to drive that truck because it's got 8 bald tires, and you've given them the pictures of the bald tires, an audible air leak in the brake system, a leaking hub seal, a damaged windshield, and 30 marker lights that don't illuminate. And you say, I'm not going to drive that truck. And the boss says, you're fired because you won't drive that truck. Great case on liability. But you don't sit home and not look for work. You have a duty to attempt to mitigate your damages by looking for substantially equivalent work. Now, suppose you're a UPS driver and that happens to you, and you're making $160,000 a year and you're home every night. No, you don't have to look for a job that takes you out over the road, away from your family for 2 months, 2 weeks, or even 4 days. You have to look for work that is substantially equivalent to the employment you're fired for in terms of pay, benefits, and terms and conditions of employment. So you don't have to take a job working for some dude who is in Chicago with 4 trucks with junky trucks. If you have a job that kept you out over the road for 6 weeks, you've got to look for something that's at least as on that level or better. So same thing applies in the case of, let's say you're on a dedicated account. You work 8 to 6 p.m. You're working for one of the large carriers like J.B. Hunt or Swift, or somebody of the sort. I'm not saying they're going to fire you, but say you're working for a large company that has a dedicated route that gets you home every day, and you're operating a newer level of equipment. You don't need, if you're illegally fired by a trucking company, to go, look for a job that's not substantially equivalent, but you need to look for a substantially equivalent job. We get a lot of cases where a driver is asked at his deposition, well, aren't there lots of trucking jobs out there? Well, yeah, but it may not be substantially equivalent to the job you had, which doesn't mean you need to go take a lease purchase job. You need to eat when you get illegally fired because lawsuits are not completed overnight, but you need to look for substantially equivalent employment if you are legally fired and can't turn down something that is substantially equivalent. I mean, you can, but it would cut off your damages at that point. You don't get to sit home and hope you win your lawsuit and you're get all that back pay for sitting home for 2 or 3 years. And a lawsuit can sometimes take that long. So that is a brief summary of the duty to mitigate in employment law cases. Thanks for watching.